Okay guys, you ready?
Yes.
Okay, before we get to the open source software or free software, whatever you'd like to call it, we'll end with that. I thought it a good idea to just, if you're not making use of either Creative Commons or open source software, open source licensing formats, again, depending on your needs, you might want to sculpt your own licensing agreement. And that's a very important part because, as we can see, licensing is terribly important. The basic concept of a license is just providing another party or parties down the line with the rights to do what copyright allows only you as the creator of the work to do. So that's in essence what a license is. You provide other parties with the right, and in return for that, you get the benefit, which is usually in the form of royalties. So whether you licensing in or licensing out, meaning whether you the licensor or the licensee, it's a very important process to consider once you actually reach that stage, because this will determine the success of your invention, because this is the bread and butter part, so to speak. This is where you either make the money or you don't, or you end up losing money, or you end up having huge problems protecting your rights. So this is terribly important, and I've been alluding to some practical things you can do to make this stage a little bit easier. Like, for instance, preparing your notes, getting the right people on board, because a license, except if you're using a standard form license, like the Creative Commons or some of the open source licenses, this is based on negotiation between you and the other party. So this is where you set in stone the agreement between the two of you. So it's terribly important. So you need to think of all the angles, everything that can go wrong. Excuse me? Yes, a lot of things can go wrong. The obvious thing is, well, there are a lot of obvious things that can go wrong. Even stuff that are out of the control of both the parties. You've all probably heard of the term, I'm not French, but force majeure. If something happens that's out of the control of anyone, it's just, let's say, a freak of nature. What happens to your product? Or what if something happens, what are the individual responsibilities of the parties? If you don't think of that eventuality and it happens, who's responsible for what? Who bears the risk? In terms of that license, does that person still pay you? Or are you still liable to provide whatever you promised you'd provide in terms of the license?
It is a form of protection, or
it's definitely
it is a responsibility.
This is a very important form of protection, because the categories of rights we've discussed during the past 2 days. We've discussed manners in which you can obtain those rights and the grounds in which you can obtain those rights. But once you have them, the most important part is what you do with them, isn't it? Because that's the execution part of it all. It's important to acquire those rights in the correct manner, but a licensing agreement is one of the most important ways in which you practically manage those rights. So it's important to, once you've acquired those rights, to protect them adequately. And the licensing agreement is the actual place where you state how you protect your rights, what other people can do with your rights, what flows from your rights. So it's terribly important. If you let's get on the internet here, Tricia. Sorry. Internet, please. Yes.
No, this one. This you prepared this one.
Oh, is that yours?
One, yes. Choose another window. Or another tab. No, all of them.
All of okay, thanks. Let me just. This will probably be easier. No. Just to the WIPO main site is fine. I'll get round to going into the WIPO.int. There we go, thank you. Just as a general comment, the WIPO website is a wonderful source of information regarding all forms of intellectual property. Here you can see they discuss the patent cooperation treaty, domain name dispute. You get the most wonderful resources and stuff on any aspect of intellectual property you can think of on this website. So go play around there as well. If you need something, go see if you can't find it on this website. Okay. Where did I? Now, just a quick search on licensing and see what you can already get. There is a very nice document that will help you negotiate technology licensing agreements. And there's another one. Let's have a look at that one. It's like a manual that takes you through the stages of licensing. It includes the negotiation part, which is important. It tells you about the clauses that they think should be in there. They recommend certain clauses. They even give you examples of the wording of those clauses. You see there they list the categories of intellectual property we spoke about in the past 2 days. They tell you about the different types of licenses you get. This is basically what a license does. It's two parties and it tells you what the responsibilities are. It regulates the relationship. And there you can see it's very important once you start negotiating your license agreement to be properly prepared. You need to go into your negotiation and you need to at that stage already know what you want out of this and how you want it. You can't negotiate with the opposite party and they're in a stronger negotiating position than you are. Because then you'll just lose out. If they've got their ducks in a row, so to speak, and you're sitting there waiting for them to make suggestions or tell you what they want, you're going to be the party that's not in the strongest position. And this is a negotiation, it's a power play thing. So whenever you think of licensing, and you're not using a standard form of license, you need to think about all the different aspects again. You can't sit there and decide, let the other party tell you how the royalties, for instance, let's say the money part of it, which is a very important part, how the royalties should be calculated. You should have a strategy regarding that beforehand when you go in. So there you can see it, it's very nicely presented graphically. The physical negotiation part is only the end part. You need to think about all the different aspects of the agreement you want in there. And then at the end of the day, your negotiation would be rather successful. And there they have some nice tips on the physical process of negotiating a license. See there, if you look at all of those aspects, would you have a team negotiating on your behalf? Would you have an IP lawyer, for instance? Would you have the people that helped you develop your product? Just something as elementary as choosing the right people on your team when negotiating your license agreement can make a huge difference. There it states what I said earlier. What's your positions on key issues of the license? You need to know that beforehand. What is the subject matter of your license? Obviously, it's the product you developed. So you need to have an intimate knowledge of that. There are some other tips. Beware of licensing technology for which there is no clear written specification or documentation. Obvious thing, but very important. We don't often think about that. That's what we've been speaking about the last 2 days. Who owns the IP that underlies the technology? Especially for you guys that work with software. As we said, all those scenarios we spoke about, incorporating other people's work, employing people to do the work for you. This is where it all comes together, so to speak. You need to be clear on who owns the IP. And remember, licensing works both ways. So this is not only if you want to license your product. It's also if you conclude an agreement, if you are the licensee. If you're the party on the other side, if you want to use someone else's technology or someone else's product. So this is relevant whether you're on either side of the table. So you need to consider these things, whether you are the licensee or the licensor. All of these aspects are important and very helpful. Because remember, a licensing agreement is providing someone else with the right to use your assets, your rights. So you need to be clear on which rights it is that you're licensing. You can't license something that's in the air, all your rights, because it's not defined. You need to be very clear on what you license, because then it's easier to determine whether there's infringement or not. It's easier to determine the royalties you'll be able to charge. It's easier to determine if something goes wrong, whose responsibility it is. So you need to be specific on the rights that you license or that you're getting. Because you might think if you need someone else's technology and you get a license to use it, all of a sudden when you look at the small print, You're only allowed to use something that won't really help you. It's only a small little part of what you thought you're getting for what you're paying. And that's possible. It happens often. People think they're getting something and all of a sudden they're infringing. And they said, but we have a license. And if they pointed to the specifics of the license, they realize, my goodness, I didn't really get what I thought I was getting. And it happens. So you need to be terribly careful and sure of what rights you're either licensing away or licensing in. It sounds simple, but you need to be careful because it happens. And then be specific. Remember all the copyright associated with the owner of copyrights. And then also, we're not talking only about copyrights here. We're talking about patents. We're talking about trademarks. So you need to be clear of what the person you're licensing your rights to, and vice versa. If you're on either side of the table, what are your rights? To reproduce, display, modify, distribute, or sell. You need to be clear about that. Something we don't think about when we license, as we said, all intellectual property rights are territorial. If you get a license to reproduce or sell, and you didn't make sure for what territory it is, you thought it may be for the whole of the national territory you guys are from. And then all of a sudden you get an infringement letter, and it was only for the province you lived in. It was only for the province you lived in because the licensor had other license agreements with other parties. So instead of only getting the royalties from one party, they're getting the royalties from 5 parties. But when you negotiated the license, you didn't pay enough attention, or you didn't read the document properly, and you realize you only got a license for the one province, for example. You see why you need to be careful, and why you need to consider all the aspects in detail. So if you're ever in a position like that, turn to documents like these to remind you of stuff to look out for, to provide you with those essential tips you need. More or less what I said earlier, is the commitment exclusive or are there others? That's important to know. Because the person can license his rights to as many people in theory as he wants. And then they, in essence, are competitors. And if they're a bigger company with more resources, you're paying royalties, but your chances of being successful are severely limited because there are other people with the same rights as you.
When do you start paying royalties?
Excuse me?
When do you start paying royalties?
That's another thing you need to think of. We'll get to that just now if you look at this manual. When that's stuff you need to negotiate. When, at which point in time, or after which event, those royalties become payable. Is royalties payable on a quarterly basis, a half-year basis, a monthly basis, a yearly basis? How is the formula for calculating the amount of the royalties? Is it the percentage on the sales? There are various different factors that can influence how the royalties are calculated.
I thought it was one-time thing, the royalties. You pay just at one time and then that's...
It depends.
No, there are various different formulas by which royalties can be calculated. And various different things influence how royalties are calculated. Just before I forget, talking about royalties, it's something to maybe just mention is, in the context of copyright, is collective societies. You've probably heard of them. Because let me explain that concept very quickly so that you just know what that is. in copyright we get collective societies. Because of the principle behind the collecting society, I'm sorry, not collective, collecting societies. My brain is not, I'm so tired now. Collecting societies, the main aim is that it's difficult for individual copyright holders to firstly protect their rights and secondly charge royalties for if their works are used. For instance, songs,
Yeah, music industry.
music industry in particular, or the film industry, television, broadcasts, even performers, actors. They have certain royalties on there. Let's take the music industry. That's probably the easiest. In theory, based on copyright, you should be rewarded for your song, but it's difficult for each individual artist around the world, or even in a small community or in a specific country, to individually try and get hold of the royalties, get the royalties back which they deserve for their creativity. Now what these collecting societies do is they basically pool the artists together. This is very simplistically explained, but the basic idea behind it is they pool the artists together. You get various different collecting societies in countries, regions, continents. So an artist would then belong to a collecting society, and they would control the works of all of the artists belonging to that collecting society. And they would, on behalf of all the artists, collect the royalties, and they would distribute them to the artists according to certain formulas which are agreed. So if a song needs to be used for a movie, someone wants to use the song for a movie, or the song wants to be performed at a concert, you can think of numerous examples. Then the collecting of the royalties is done by the collecting society and not by the individual artist, and the collecting society is responsible for managing the collecting and the distributing of the royalties. Does that make sense to you?
Yeah.
Okay, great. There's what you just talked about, the royalties part. How much will the licensee pay for the use of the technology? And then stuff to consider is how much are you willing to pay? What other costs do you need to incur? And then I'm not going to go into much detail there. You can go and have a look yourself if you want. But how the different ways of calculating or working out the royalties. There are many different ways. I'm not going to bore you with the details of that. There are the important parts that I referred to briefly earlier. You need to stipulate how each party must perform in terms of the agreement. It's like a normal contract. I'll do this, you do that, but you need to be very specific. Are there any warranties? Are there any indemnities? You guys know what an indemnity is?
Yes.
Right.
Not me.
So, indemnity is just basically if something goes wrong, I won't hold you responsible. I indemnify you. That's basically a very simplistic definition of what indemnity is.
Thank you, I'm good.
And then something that might be relevant to you guys, depending on who you work with. If you're involved in a collaboration of some sort, or a joint venture, you have partners, you have people that invested in your project, you need to consider their needs as well and the arrangements and agreements you have with them. Like this program, once you have a successful venture, innovation, whatever, and you went through all of these processes, and you now want to either commercialize or license your rights, you need to keep in mind that there are other people that help you get there. And you need to honor those commitments, whether it's employees, people that contributed in a financial manner, people that you made promises, even if it was just on a handshake. Because now you have the rights, and there are people that helped you get there. You might have signed agreements. You must remember that you signed that agreement. Because sometimes, I've seen it in the past, people get carried away. And sometimes the end product only comes a long time after you've made a certain promise, or you've signed an agreement. All of a sudden you license your rights and you forgot about the agreement you signed 3 years ago, or the promises you made to people, or the money you should have paid back. Stuff like that. So you must honor your partnerships. Think about it. If it's a joint venture, if it's a partnership, remember the effects of licensing your rights away would have on those people or those parties. It's important. Just something as trivial as this that you don't think of. You're dealing with a product that you've developed now. But what about consequent versions of the same product? Or a new product that might replace the old product? Did you address that in your license agreement? Or would the license agreement be stated in such general terms that if you developed a new product, that if the general terms are read, that you might have licensed in reality your new product as well?
It depends on the contract. Some of the contracts, if a newer version of some of the features of the old are developed, you have the right to it. But any new additions to it, you can only have access if you pay for that. But whatever you paid for, you are using. When we improve upon it, you have access to it. But any other feature that has been developed, you will have to pay to get.
But you need to, what I'm saying is you need to state that clearly, because it can't be assumed. And if if your contract is drafted in such general terms, then, and it can be read that, it can be understood or interpreted is the correct terminology to use. It can be interpreted that it includes the new improved version, so to speak.
Yes.
So you need to be specific regarding all of those aspects. Otherwise, you know, you might draw the short straw. Support. What happens if something goes wrong? Are you responsible for providing support to the person you license to? Or if you, the licensee, something goes wrong and you didn't include the aspect of support, or let's call it after-sales service, and they just say, but it's not my responsibility. I provided you with the technology or the product or the end result. It's not my responsibility to teach you how to use it. It could be true, because training is expensive. After-sales care is expensive. You need to employ people to do that. It takes time. It takes a lot of resources. So if you don't specify that, and it's not included specifically in the contract, and you need support, then you can't get it.
I think in the technology industry, sales or getting contracts is based on referrals. people refer you. It's difficult getting people just walk into your shop or your office to get you to do something for them. So, and if you give a product to someone, training is the key for the person to understand and use it well. If you don't train, the person's referral will be negative. So training is key. However, there are some things that if you don't anticipate, then you should be able to state in the document that those things can be settled through negotiations. That okay, what can we do? Okay, due to this situation, maybe you pay 20% of what the actual cost will be, or we do it for free. So
yes, you see, that'll again depend on the specific circumstances of that specific situation. The idea I'm trying to convey here is that you need to think of as many of these situations as you possibly can. Because when you leave it open to negotiation afterwards, then by the time you start negotiating, all this the fact that you're negotiating supposes something went wrong. And then it's not an equal negotiating platform anymore. One party has leverage over the other party, and then negotiation isn't the best, the ideal thing to sort out a problem. So you need to think of as much as these factors as you can, to already from the very start have a clear specific contract dealing with every one of these situations. So that if something goes wrong, it's already decided beforehand.
Would a separate document, say a service level agreement, be easier to manage separately from the license?
Yes, depending on what you're trying to manage, depending on the situation. There are numerous other contracts, and there's a list that I'll show you just now that can, by reference, be incorporated into the agreement. For instance, a confidentiality agreement can be annexed. If it's not contained in the contract itself, it can be referred to and annexed as an annexure to the agreement. There are distribution agreements, for instance. Because a distribution agreement can be a very long, complicated, legalistic document in itself. So you wouldn't necessarily include it in your license agreement. You would annex it, or you would refer to certain clauses of it, or just to the agreement in general. So you'll address it, but there are numerous other documents that you can refer to in your license agreement. And then future relationship of the parties is also important, because it's all about relationships. And then there are some tips about conducting negotiations of the agreement. It's very interesting. We don't have a lot of time left, and this is very intricate, but go in if you're ever in this situation, or even before you're in this situation, just go and read it, because it gives you nice tips. It really provides some great insight. And there you have tips on using the signed agreement that you concluded. They even have like pro forma agreements that you can insert your own details into. This is quite a nice exposition of some of the aspects we've covered. What are you licensing? Who owns it? What happens afterwards? What's the scope of the license? And another important thing that you should always remember is to think of sub-licensing. Sub-licensing is terribly important. And if you don't term your contract, the wording of your contract, if it's not specific enough and you license a right, and the wording is not specific enough. It can be argued that because you license the right, that person can sub-license. Do you allow that person to sub-license? Or do you restrict it? You need to be clear on that. And then the term is also very important. For how long does that license last? If you're not, it sounds obvious, but if you don't actually put it in there, and that person, the other party can argue, but it's for as long as I want, or as long as the right subsists. And then another thing that's terribly important, and something that you should definitely consider, is what happens if something goes wrong. This is very important because it's practical and it can save you a lot of time, a lot of money, and a lot of hassle. The new trend is towards what they call alternative dispute resolution. Because depending on whether you're in the same country, the two parties, depending on the resources of the two parties, one might be a big company, you might be a sole proprietor. There are various different things that could affect how successful you would be if something goes wrong. And litigating in a court, whether it's in America or Europe or in Africa, it's expensive. And it takes a long time. And it's not nice. So consider including an alternative dispute resolution clause in your agreement, so as to obviate the possibility of litigating. That should be your choice of your first instance choice. Mediation, getting a third party to help you try and resolve the conflicts or the dispute. The other option is arbitration.
I want to know who can grant a license. Is it someone who has copyrighted the work, or for the fact that there is copyright vested in your work, once you've done it, you can still license?
Yes, you can only license presupposes that you have a right. That's the only way you can license. You can license anything that you have a right to. So you need to have an enforceable right in order to be able to license, whether it's a trademark or a patent or copyright. Because the word license in itself supposes that you providing the other people or the person you're licensing to exercise your rights. And if you don't have a right, you can't exercise. You can't give something away that you don't have.
So can you be sued if you are licensing without you actually having a certification to show you have the right?
Yes, you need to have a right. That's what I said earlier when I said you need to be sure what you're licensing. And if you're sure what you're licensing, you need to be sure who's the owner of that right. Because if you're not the owner, you can't license it. Okay, guys, that was the one. Okay, no.
It's finished.
Yeah, that was the one. And then there's another nice example which provides you with a list of the other agreements, also provides you with a list of some of the specific clauses you should consider including. Let's just have a look at this one very quickly. Is it loaded? Oh, yes. While that is loading, do you see how many different things you need to think of? And even if you have lawyers to help you, or organizations that assist you, that provide you with some services, it's good to know these things in order to be able to know what to look out for, even if you don't do it yourself. It's good to have a basic knowledge of this. You see, this is also a very nice document for you to have a look at. Oh, it's still loading. Okay. But when you have time, you can gladly look at these documents. They provide essential information. They are very nice guides to just point you in the right direction. You'll obviously need to define your own needs, but this provides a nice structure from which to work. It will obviously depend on your situation, the rights you want to license, what you'll put in there or what you won't. It's not necessarily that everything will be needed in your licensing agreement, but have a look at the different aspects and tailor it or sculpt it to fit your particular right or your particular product. And this is taking too long, it's fine, we can just leave it, but, oh no, okay. Oh yes, something that you should always also consider, apart from all the different aspects we've just mentioned, is that you need to be aware of where you do business and the rules of the jurisdiction, national laws, legislation that govern what you're doing in that particular, because you might be doing business in your home country, but you're licensing the use of the right in another country. And if you're not cognizant of the regulations or the legislation in the jurisdiction to which you're licensing, that can have adverse effects. It can come back to you. So always take that into account as well. Okay, I don't think we don't need to go into this in any more detail. I think we can move on to the, yeah. Yes, okay, then we just go there. Okay, the last topic we'll discuss is free software, of which you probably have a much better technical understanding than I do, because I don't understand software at all. I just understand some of the legal parts of it. But apparently you all are top class IT specialists and programmers and all of that, so you will definitely probably know more about the nitty-gritty of software than I do. And I'm not even ashamed to admit that, because computers and I have never, but I understand the legal parts of it.
This is the legal part that so.
So you all basically, you all probably have a very basic idea or a very intimate idea of what free software is all about. Now, terminology are used interchangeably: free software, open software, but it's all in essence the same principle. A basic definition of free software means that software that respects users' freedom and the community. Roughly, it means that users have the freedom to run, copy, distribute, study, change, and improve the software. This free software is a matter of freedom and not of price. That's the basic premise behind it. Now, to understand it better, to understand the word free in the context that it's used, free software presupposes a number of freedoms. And that's often, I think, misunderstood by many people. What does the word free mean? Does it mean I can do anything at any time, whatever I want type thing? And I think that's where there's a lot of misconception and something to be terribly careful of. Because the word free does not presuppose that I can do anything at any time, whatever I want. So firstly, that's just a little bit of a red light. The word free does not suppose I can do anything I want. It supposes a number of fundamental freedoms. And the freedoms are, generally speaking, like 4 freedoms that they refer to, and I'll read them to you, not so that you'll be sure, because I'm messing up my terminology now. The freedom to run the program as you wish, for any purpose. That's the first fundamental freedom. The freedom to study how the program works and change it so it does your computing as you wish. And access to the source, to the source code is obviously a precondition to that freedom. The freedom to redistribute copies so you can help your collaborators, your neighbors, so to speak. And fourthly, the freedom to redistribute copies of your modified versions to others. And by doing this, you can then obviously give the whole community, whatever community you refer to. It can be a small community, a big community, a global community. It refers to any group of people that has an interest. I'm going to ask Maji. He promised to show you guys some interesting things regarding free software, because I gathered from our conversations during the week that he's been quite active in this regard. So I'll carry on, but I'll provide Maji with the opportunity to share his extensive knowledge with us and just point us to a few places to have a look at, and then after that I'll also point you to a few places to have a look at.
We were smoking a lot together.
Yeah.
Please make sure that's Patricia.
No,
You
go
don't
ahead,
want
go
it.
ahead. If you want,
Yeah. Yeah. That's it, right? That's it, right? Yeah.
Okay, just to make it easier, there is the opensource.org, and like Henry said, open source doesn't mean for free. And if you go to, for example, in Wikipedia here, I think it will say it, this one. The best sentence to say is free for freedom and not free for beer, free beer. It's not the same. You can get your open source software, but it's you have price for that. Okay, just you open, you give access to your source code and give access to distribute or modify or whatever you want. You can find a quite extensive description about what is the GNU, the GNU, the must known license. Okay, but we say GNU is easier for everybody. If you say GNU, what GNU? But the original acronym is GNU, not Linux. Unix, I'm sorry. GNU, not Unix. But we say it GNU for those who knows. The most known license are those ones that apply to open source softwares. You can take a look at them, okay? Or if you want to get a quick information about what is allowed and what is not allowed, you can go to this website, which is tldrlegal.com. Okay? For example, you can write Apache here, which is one of the license. Apache license, you can see it here. For example, the first one, it will give you a quick idea about what is the Apache license, what you can, what you cannot, and what you must.
You will see, sorry,
Yeah.
Majid, if you go into the site, you will see they actually provide you with the link to the license, the whole text of the license.
Exactly. You can go here. On
yes.
the full text.
The full text, and I would just suggest that you guys have a look at the full text of some of these licenses, because it's one thing to say that you can distribute, you can sub-license.
Yeah.
What you can't do, but I think it's important to put it into a specific context, because one could easily get caught up in what you think is a simple thing, because it's supposed, the idea is that it's simplified and not as complicated as the other licenses you negotiate yourself. But it's still important to have a look at the full text to completely understand what is meant by sub-license, private use. So you need to have a look at the details as well. Sorry, Majid, yes, I just wanted to...
Sorry, can you please repeat the link, the address?
TLDR
T
legal.
N
TLDR legal.com.
Maybe it's easier to search for Apache and follow the link. So maybe it's easier to look
Yeah,
for
if you
Apache
want, I can
and follow
send
the
it.
link.
I can send a little explanation about that. And that's it. For example, sub-license describe the ability. I'm sorry. When you click here, for you to grant extend the license, it's really something to the software, which is really important. You must think about that. It's for every contract. You can't take yourself in one fixed position. Think about sub-classing. And this is the main tool that you can find, the easiest one, who explains. If you want to take a look, like Eddie said, to the text, you go to the full text.
And I suggest that you do that just for one or two, not
Not
you
all
don't
of
need
them.
to, because
It's really annoying.
there are a hell of a lot of them. But for if they say, for instance, you cannot sub-license or you can distribute, it's put very generally. But if you look at the full text, there are some pitfalls hidden there. So if you decide on a license and you decide to use one, do yourself the favor and go and look at the full text, even though it seems simple with tools like this.
Okay, and you have here the future and the most popular. Depending on statistics, the first one is Apache license. After that, you have MIT license. And you have to simplify how many rules, 5 for what you can do, 1 for what you cannot do, and what you must think about, which is in blue or orange or the color. To go back a little bit and get better understanding of license, here you have the major categories of software, the closed one and the open one. Okay, the free are right here, the free download and the free use at the same time, the maximum of the free use. You have the public domain with source code, which is open, you can do whatever you want. The X386 style, which is known by BSD, and you have all what we call copyleft, I'll explain later, and GPL, which is the smallest subcategory of the open software. You have a free one, which is the shareware from the closed software license. If I go back to copyleft to understand what is copyleft, because when we say open software, the first understanding is the GNU, the GNU public license, what we were talking about. I will go back to copyleft. This is it. Copyleft. If you want to read, I want you to read this part, which is really interesting. In general, start from here. Sorry. No, issues. In general, copyright law is used by an author to prohibit recipients from reproducing, adapting, or distributing copies of the work. You agree?
This is Wikipedia. I don't believe anything on Wikipedia.
You agree? That's fine. Okay. In contrast, under copyleft, an author may give every person who receives a copy of a work permission to reproduce, adapt, or distribute it and require that in resulting copies, which is a really big difference between GPL and copylefted software and not copylefted. Copyright doesn't give you the right to distribute or change. Copyleft give you that right. It's really important. You can produce an open source software which is copyrighted, and the other one which is copyleft.
Yes, you see the wordplay on copyright and copyleft. And copyleft, a different definition of it can also be that when distributing, you're not allowed to take away the freedoms that were provided beforehand. That's in essence what it means. Thank you, Ali.
I want you to go, if you have time, and if you want to know a little bit more about that, you have producingOSS.com, producing open software. Okay, you go for English, for example, and you have here one of the chapters is choosing the license and apply it. Okay, you have a little bit extensive explanation, which is really fast, and how to do it. Because you don't have really to understand what is really in the text of all licenses. You have just to understand the big titles, okay, and after that to do some modification to the source code, to your software. A little bit of that. And this one will help you a lot. If you take a look here, producing OSS.
Just so back, let me see the title. Just down.
Producing software. Producing OSS.com.
ProducingOS.com. That's producingOS.com.
Okay. And you have, it's a really interesting book. Okay, you can go, it's free. Okay, but you cannot reproduce. That's it. Thank you.
Okay, thank you very much.
So, my basic issue is software like Ubuntu,
Linux, let's say.
Linux.
No.
All of them are Linux.
Ubuntu is Linux. Linux have distribution, can be Ubuntu, SUSE, Fedora, FreeBSD, all these things is Linux. So they have different distribution, like Windows, Microsoft, you have Microsoft, Windows 7, Windows 8, Windows Vista, like this.
I'm sure it's
And I'm
just
talking about, I don't know whether you know the
But it's different. Microsoft.
the structure for programming, Laravel.
I'm sorry, I didn't hear your question. Stop talking. You mean? Let him explain.
Sorry, I'll come back. I think it's mixed up in my head.
yeah, it's 5 o'clock.
It is not free.
But
I
for
just
Windows, it's the same
God,
company
it's
that
disappearing.
made Windows 7 and Windows XP and
It's
those.
what
But for Linux, it's different.
a lot of people
No.
contribute.
Ubuntu is different, SUSE is
Yeah.
different,
No.
but all of them are based on the same
The main
kernel.
idea behind the
Yes.
open software, I
It's
didn't tell
different.
it maybe because
Yes.
I
They
thought
are based
it's
on the
always
same kernel,
is to
but
really
Yes,
promote
all this is-
creativity
okay.
and to
we
be
call this
open to all the work.
distribution just because they don't want the same, because they have different distributions. So for this is not a version. Windows we have version.
Yes.
In Windows we have version. In Linux we have distribution because they are not the same.
Yeah.
Okay? Because in Windows we have Windows
Version is version.
8 is something to correct some bugs and have some more things that Windows the
It is-
previous.
It is
So-
the same company.
and it's not for free.
It's the same company.
It's not for free. You have to pay it. Is the
Bernard,
waste software, the
you don't want to know
operating
how
system that
how
we
to make money with
We
this
have.
license?
Yes, it's the GNU website.
Open source. Okay.
If you go here, you'll find extensive information regarding the whole movement, and something that's very, because we won't have time to go through all the individual licenses now, but something that's very useful to use. Well, everything here is useful to use, but just to add what Maji has said, if you go to
Touch again.
touch it again. If you go to this list, it's quite a long list. It's this whole printed thing, so there are a lot of them. But they explain the basic license shortly, and you can then go have a look at the license as well. And then they explain how the licenses differ from one another. So it's a good list to use to be able to determine what license will fit your needs the best. Because they tell you exactly what it is. Let's say the lesser general public license. It doesn't have strong copyleft because it permits linking with non-free modules. And then they also give you suggestions of where to apply. They're all permissive. There they explain the Apache. So this is a very good place to start looking for the appropriate license and how the licenses differ from one another. You'll see there are lots of them. There are lots of them. There's the Mozilla one. They also tell you whether the license is compatible with other licenses. They make suggestions. So this is a useful tool to try and find the license appropriate to your needs. Okay. And then they also tell you incompatible licenses.
This is it under licenses.
Yes, it's the GNO website. You can play around there, but here they list all the free licenses, all the open source licenses, and they also tell you how compatible they are.
Okay.
How the licenses clash and how compatible they are. Okay, I think I'll allow a few minutes for any questions because we're out of time now. So let's open the floor for discussions or questions, or generally speaking about the past 2 days, because we won't be seeing each other again, or not formally in any case. So if you have any thing you're not sure of, any questions, any comments, you're more than welcome to ask them now, or make your comments, or start a debate or whatever.
In a country where you are not allowed to patent or have copyright to software, can you do that in a different country? In your own jurisdiction, you can't do it. But can you apply in a different jurisdiction?
Yes, you can. Yes, you can. As long as your whatever you're trying to patent complies with the formalities or the minimum requirements set for protection in that specific jurisdiction.
So if I pass through that and I'm able to get that license, and maybe after 1 year grace period as provided, I'm able to apply for the international license. What is the impact on the jurisdiction where they don't allow patent or copyright for softwares?
You'll need to apply for that specific, comply with firstly with the principal filing of with the national jurisdiction. But if you, for instance, apply through the Patent Cooperation Treaty in other jurisdictions, then if the Patent Cooperation Treaty, if your patent is found to be patentable in terms of the PCT, then every individual nation who's a part of the PCT, you don't need to comply with those of every individual. If it's part of the PCT and the PCT grants the application, then you presume to have complied with all the individual requirements of every individual state that the PCT covers.
I'm going to put you on the spot. Right. Seriously speaking, the FIRE grant has given us openings or promises for other big monies, and after going through these 2 days of
Promises, if I understand you correctly, are you suggesting that it's incentives? If
Patricia promised to offer another.
no, not from FIRE, but I'm just saying it opened up doors.
Yes.
To, I mean, because
so they provided incentives, okay, opportunities and incentives, and okay.
So this to me has given me that mentality that, you know, patenting and branding and whatever has to make quite a big part of your budget, your financial budget. So, if I were to approach you, how much would you charge?
The question I want to ask.
How much would you charge me to help me at least get not a patent, but maybe a trademark for starters?
See, I always take the easy route out. I deal with this in South Africa, but because I have, to be honest, to give you an honest answer, numerous jobs, so to speak. I'm not a practicing patent attorney. I advise, but the actual physical registration of trademarks, because in order to be able to do that properly, you need to have a huge administrative, like a law firm.
Okay.
You need someone to manage that process, because you need to check renewals every day. You need to go to the registrar of trademarks and patents, the patent office every day, in order to file the application. So it's a huge administrative burden, and if you don't do that on a permanent basis, you're going to drop the ball, so to speak. So I don't physically register trademarks myself, but I have people that I use, and because I use the people, and because I have good relationships with them, because I use them often, I refer people to them often, I usually get good discount rates.
Okay.
Yes.
In terms of advising, because for us, it's a little dicey, maybe to advise, this is where we are, or it's possible, you can do it this way, how much? And what do you think the startups of Africa, especially the youth IT startups, should do? Because it's a huge problem. There are a lot of startups and a lot of innovations, but as to how, some don't even know the offices exist in their country.
Yes, to be honest with you, I don't have the ideal solution. Because I see it all around me in my country as well. Even some of my friends, you can advise and you can point in the right direction. But there isn't a list of things that I can give you to say that you need to do this, then you definitely will be successful. As I said yesterday, if it was easy, then we would all be rich. You just need to, I'm becoming a little bit philosophical now, because I don't have a straight answer, but just never give up, always work hard, see setbacks as learning opportunities, and just always keep believing in yourself. But I know it's difficult, and unfortunately, if I had that recipe, I would have probably, hopefully, been living in a mansion on Mauritius. And
okay. But with the goodwill of Patricia, what advice, what would you be able to advise us in terms of maybe general, if we are able to send you maybe some documents, just to advise what route to take and looking at it?
I would be able to, in terms of what I know more of, which is intellectual property law, I will be able to point you to certain intellectual property management best practice type scenarios and information that I'll gladly do. That I'll gladly do for you guys.
Okay, so
but how to really run a successful business, I can point you to how to properly manage your intellectual property.
Yes, that's
there. I can point you to some nice resources, and that I'll gladly do.
Okay.
Yes.
Okay. So, through Patricia, we'll send you some document just for advice, and maybe where we should start. We won't miss that. Okay. Thank you for your services.
Okay, guys. I think any more questions or comments? Can I close the proceedings officially? Thank you very much. I enjoyed my time with you guys.
Wow.
And from my side, I wish you all the best. I hope all of your projects are wonderfully successful. And please, if you have that big launch, or you receive that first royalty check and you're not sure what the hell to do with it, please invite me to your launch of your product, or just invite me to your country to have a look and stick me for a drink and a dinner.
Yes, but for free. We'll not pay.
Yes, you must just get me there and buy me the first whiskey.
Yes.
Yes.
For me, everything is for free. It's Guinean.
Thank you very much. But yes, on a serious note, I wish you all the best of luck. I really hope. I have confidence in you guys. You all seem very eager and very committed, and I really wish you all the best with your individual projects.
Thank you.
Thank you. We'll give the word to Ryan to speak on our behalf.
Why? Okay. Well, on behalf of everyone, we'd like to thank you for the wonderful day we had. It was lovely to have you, first of all, but also to learn. I think we all we hear about copyright and stuff, but to have a bit of detail about it was really fantastic over the last 2 days. So thank you for that, and thanks to FIRE, Patricia, for organizing this wonderful workshop, and to the cameraman as well.
All right. So,
It's your.
That was good having you, and I'll see you soon. For those who are leaving tomorrow, we're not done yet. We're having our presentation tomorrow, and then you will be free from 1 p.m. So enjoy your evening, and I see you tomorrow. And I would like to thank you again, Eddie, for coming. I met Eddie when that was in May during an ICANN workshop on intellectual property, where I learned a lot. Even if I have a low background, and I also studied intellectual property. So at that time I knew I would organize one, and that he would be the facilitator. So I'm really happy to have him here. And we'll do another one soon.
Thank you, guys.
Thank you.
Thank you.
We are so grateful, Randall. But I think one last request, we requested some of the notes, maybe. The ones you already have, not related.
Oh, you could make up.
Yeah, just.
Yes.
But the PowerPoint, we will need it just.
Yeah.
Yes, I'll send you the PowerPoint, and I'll add a few links and stuff for you guys. You must just give me a little break. I'm quite busy the next few weeks. Maybe early next year, I'll send you a nice email.
Okay.
With some nice resources and the presentation and all of that.
So
just point you in the right direction. Yes.
In case you make a book of the notes, remember the copyright, huh?
No, I think you use common
Common
creative commons.
Create common
I will just acknowledge, you know, but it's been good. And the food. Wow.
Thank you, guys. Have a good evening.
The camera's off.
Yes.
Oh,
No?
Now we need to talk about the
So what? The paint?
About what?
non-African.
No. She's tired and
South
hungry,
Africa.
and she'll be really hungry. For
We're
after.
all tired. Yeah, everyone is tired.
But those leaving tomorrow, so what can we do this evening?
What?
Party.
This time, Patty didn't organize a party for us.
I'm not going anywhere. Just to let you know.
No.
No flicker flag.
No flicker
No
flag.
flicker flag.
My partner's crossed with me.